Hello, hidden gems. How's everyone doing today? Uh, I don't know all about all of you, but I am so done with Lori Vallow Daybell. So done. I'm gonna have to probably figure out when to stop covering her consistent motions, but not today. Not today, because I want to go through this with all of you. We need to go through it. Because just when you thought Lori Daybell might finally be waving a white flag, and did any of us really think that? But, we always keep hope, right? Maybe, just maybe she's waving this white flag, maybe settling into her life sentences, her multiple life sentences, wanting to go back to Idaho, right? Because she hates Arizona so much. Maybe finally she's going to be quiet. She pops back up with emotion that screams, "Not so fast. Oh, don't forget about me." Yes, we went just under a full 2 weeks, 2 weeks, guys, without a single court filing from her after her latest guilty verdict, her last, most recent guilty verdict. And honestly, that might be a personal best. But as she reminds us, don't get too comfortable because the so-called doomsday mom is back in action and she is demanding a brand new trial. And why? Why is she demanding a brand new trial? Well, one reason, according to Lori, was she was too sick to stand trial. Surprise, predictable. Yep. Now she is claiming she was forced to be in court while allegedly battling from nausea, everything from nausea to headaches. And while she didn't mention it yet, probably spiritual distress. And that's just the beginning. We may or may not know about the spiritual distress, because of HIPAA. But despite this predictable move, we could have guessed that as soon as voir dire was happening and she claimed she was too sick and she wanted to delay her trial. But in this episode, we are going to go line by line through her latest motion. What is she arguing? And does any of it hold up? Because, there were a couple lines we'll talk that got my attention. I don't know. And we're about to see the next wave of Lori's courtroom chaos possible. We'll see. And if history tells us anything, though, this isn't going to be the last filing we see, not by a long shot. And so, like I said, I'm going to have to wonder when I'm done or when all of you are done and when we decide to be done, because this tells me she might never be done. And so let's begin, though. The motion reads, quote, Lori Daybell requests that the court grant her a new trial. This motion is filed pursuant to the protections provided by Rule 24.1 of the Arizona Rules of Criminal Procedure, the Fifth Amendment Due Process Clause, Sixth Amendment Confrontation Clause, and the 14th Amendment of the United States Constitution, and Article 2, 4, and 24 of Arizona State Constitution. This motion is accompanied by the following memorandum of points and authorities, end quote. So, under memorandum of points and authorities, argument 1 is titled Fourth Amendment Violation Medical Evaluation, and it reads, quote, on Friday, May 30th, the defendant became ill, vomiting at the lunch break during jury selection. So we were out during the lunch break, but allegedly she was vomiting. And after lunch break, the defendant informed the judge and state of her sickness and that her investigator had been out sick since the prior day with the same symptoms. Again, I just want to reiterate this. I want to stop for a second and say, we never heard she was vomiting. I'm not saying she wasn't. Again, I wasn't there. But we were told that she wanted to vomit, that she felt nauseous, but no one was ever told she was vomiting. But let's go on. The court asked the defendant to stay for 10 minutes while he informs jurors and releases people with scheduling conflicts. Defendant was reluctant and did not want to vomit in front of the jury. That part I remember. She said she was going to throw up on the television. However, The judge refused to dismiss her. The 10 minutes turned into 1.5, turned into 1.5 hours. Before being dismissed by the court, he advised defendant to let the court know through her team before Monday if she was still sick. And on Sunday, June 1st, excuse me. And on Sunday, June 1st, defendant was still sick and had her advisory council email the court to inform them that she was still too sick with a virus and could not proceed on Monday, June 2nd. Monday, June 2nd, 2025, defendant was very sick and had advised the court in a timely manner. However, the court sent an order to the jail on June 2nd, 2025 to have defendant brought to court by any means necessary. Defendant could not walk from being weak and dehydrated, having vomited all weekend. Maricopa County Sheriff's Office brought defendant to court in a wheelchair. We all remember the wheelchair. Defendant then explained to the court that she was too sick to represent herself and would not go forward. The court again asked the defendant to stay while he brought in potential jurors to explain and ordered her out of the wheelchair and into a regular chair. Also, I will put out, he didn't order, he requested that she get into a regular chair for to stop, biases but I'll continue. I guess there's a part of it that just wants to point out all these things that aren't true that I did see, because again, the boy who cries wolf, I'm going to doubt some of the things I can't see too, admittedly, but let's keep reading. They say that she was ordered out of her wheelchair and into a regular chair. Defendant argued the last time he said 10 minutes, which took over 1.5 hours, so he dismissed her prior to dismissing the jury. The defendant was then left in the wheelchair because, again, she didn't get out of that wheelchair, in a holding cell with no blanket, medicine, or hydration for 6 hours, waiting for transport back to the jail. I will point out, I didn't see what happened in the holding cell. If she was denied water, I am concerned. That's a problem. On Monday, June 2nd, 2025, the court sent an order to Maricopa County Sheriff's Office requesting they medically evaluate defendant, which is a violation of this defendant's Fourth Amendment rights in Arizona Constitution, Article 2, Section 8. June 3rd, 2025, Maricopa County Sheriff's Office called defendant out of bed again to walk down to medical. This is true. We did see the orders saying that she was forced to come to court. That is true. This is Lori's side of the story. It's sort of like there's two sides to every story. Here's Lori's story. Maricopa County Sheriff's Office ordered CHS, that is the Health Services, Correctional Health Services, CHS, to evaluate the defendant's health without her knowledge. I'm pretty sure she understood it when they came and said that we're here to assess your health. But Maricopa County Sheriff's Office ordered CHS, the Health Services, Correctional Health Services, to evaluate defendant's health without her knowledge, and CHS then provided their evaluation to the court through Maricopa County Civil Attorney Joseph Vigil, which was a HIPAA violation, according to Lori, and the notice filed on June 3rd, 2025, initially not under seal. So I guess this wasn't under seal, thus that violates her HIPAA. On Wednesday, June 4th, 2025, this court ordered again defendant to court by any means necessary order by Maricopa County Sheriff's Office. True again. And any means necessary order means guards show up at your cell and pull you out of bed and take you to court against your will. That happens. Once in court, defendant again informs the judge that she cannot proceed because she is too ill. Judge Bresky orders her not only to stay, but to defend herself while too sick to do so. Defendant was then forced by the court into voir dire, the jury, and to select a jury. Thursday, June 5th, 2025. Again, now this is the first day of trial. Thursday, June 5th, 2025. Although defendant was still suffering from a viral illness, she was expected by Judge Bresky to give her opening statement and begin cross-examining witnesses. Friday, June 6th, 2025, Judge Bresky ordered defendant by any means necessary to again defend herself sick in a full day of court from 8:30 a.m. until 4:30 p.m. Sunday, June 8th, 2025, Defendant's Advisory Council again emailed the court that defendant is still sick and that she had been notified by the Correctional Health Services of the results of the testing performed, and it came back with an infection in need of antibiotics for treatment. Also, that's interesting because it didn't come back for a viral, or is that a viral infection, I guess we're learning? Needing antibiotics? So we don't know anything else? Okay. Yet again, by any means necessary, order was entered by the court for Monday, June 9th. Monday, June 9th, 2025. Judge Bresky cleared the courtroom and sealed the hearing. Now there was actual evidence that the defendant had really been sick the whole time without treatment. And in the end, Judge Bresky still ordered the defendant to defend herself at trial, knowing she was too ill to proceed. The by any means necessary order continued from Judge Bresky, and it continued every day through the trial from May 30th until June 12th, the day the verdict was given. So that's interesting. We know now that this order was likely given every day of trial, and she didn't want to go. I also want to point out there was this one day where Lori, in front of the jury, she stands, she acts the part, and then when the jury leaves, she pretends, or not, excuse me, I shouldn't say pretends, but she says she is too sick, and the judge pointed that out and had that on record. But let's continue. This is a violation of the defendant's due process rights under the 5th and 14th Amendments of the United States Constitution and Article 2, Section 4 of the Arizona Constitution. This alone constitutes a new trial, end quote. So, again, I will say that Lori's statement here, I'll quote it again. The defendant was then left in a wheelchair in a holding cell with no blanket, medicine, or hydration for 6 hours, waiting for transport back to the jail, end quote. That does concern me, specifically the lack of hydration. Waiting for transport, understandable. No blanket or medicine or water, something she should likely have. But I don't know, again, what happened in the holding cell and just what Lori tells us, what is true and what isn't true, because I've already read a lot of things so far that I saw with my own eyes that simply aren't true. But okay, I don't know what happened in the holding cell. Fair enough. I maybe she didn't have those 2 bottles of water she always had on her desk, her defense desk. I'm also curious about the infection she had that she needed antibiotics for. What was it? Was it a urinary tract infection? Was it something more severe? Unfortunately, the public doesn't know these things, probably because of HIPAA. But yet she's saying there was a HIPAA violation, but none of us know what it was. Anyway, Lori's next argument for a new trial is the court's lack of impartiality. So if you remember from her filing to get a retrial in the case for Charles, she had the same lead argument. She had cited the judge saying, quote, I guess to the extent that you are comparing yourself to these biblical figures, I will allow it, end quote, in that motion. Well, this time, here is what she is saying, quote, the court precluded this defendant from presenting her case by not allowing defendant to argue objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents from him prior to cross-examining witnesses. And we're going to take a little bit of a break here because I need some water because we got a lot to go over here. Thanks for your patience, guys. I want everyone to know that's written me. I have been to the doctor about my ongoing cough, and I'm getting x-rays, and I am taking care of myself. So we will get that figured out. I also have an inhaler in the other room. But we have a lot to go over, so forgive my interruptions. I feel terrible about it. I'm on my way. One more sip before we continue. Okay. One thing I'm doing though, despite my cough, showing up. Oh, and by the way, I'm not in a wheelchair, just a nice, comfy swivel chair. All right, here I am. So let's continue. Quote, to begin, this defendant, in attempting to cross-examine the case agent regarding the investigation done at the scene by initial responding officers, was denied that opportunity, end quote. And then Lori cites a specific timestamp in the court footage, which we can take a listen to here. So she cites this. Take a listen.
And so did you learn from Officer Rob that the neighbor that she had got contact with said that the Jeep had a tire on the back?
Sustained. Sustained.
Your Honor, I wasn't asking for the truth of the matter asserted. I was asking for the effect on the listener. Officer
Sustained.
Rob,
Sustained.
can I have a sidebar?
No, it's sustained. Next question.
Lori goes on to say, quote, the initial responding officer spoke with a witness who provided a different description of the Jeep she saw during the incident. Defendant attempted to cross-examine the case agent when the state objected to the answer based on hearsay. The objection by the state was sustained. Defendant, even though not having been asked for a response from the judge, argued the statement was not being used for the truth of the matter, rather to show effect on listen. Defendant requested a sidebar and was denied. This same interaction occurred with another scene agent, Detective David Freer, and when defendant attempted to cross-examine him regarding what other neighbors told police they heard during the police investigation, a hearsay objection was sustained without allowing defendant an opportunity to respond. Lastly, defendant put on the record early in the case that her investigator, Jeff White, had been out ill. The court requested defendant's advisory counsel work with investigator White to obtain documents and exhibits that she would need to cross-examine witnesses. Photos were received by advisory counsel and were not able to be printed in time to use during cross of Detective Freer. Those exhibits are attached as Exhibit 1. Defendant also was unable to admit Exhibits 192, 193, and 194 as a state, and the court continued to state she would be opening the door to her prior convictions. That's true. They did always warn her that she'd be opening the door to her prior convictions because she was. Additionally, I'll continue, quote, additionally, the state continuously stated defendant's line of questioning relating to Melanie Boudreau constituted a third-party defense, yet defendant never attempted to blame Melanie Boudreau for the crimes. Defendant was simply attempting to cross-examine the victim, Brandon Boudreau, as to why he blamed defendant. Exhibits 192, 193, and 194 are attached as exhibit, end quote. Okay. So now to this I can speak because I was there and I saw and I heard what Lori was saying. And in my opinion, as someone just sitting in the courtroom, she absolutely was blaming her niece, Melanie Boudreau-Pulaski. I don't know what else that is. She might claim she wasn't. She might be saying that she was trying to point out that Brandon shouldn't be blaming her because she's the one that would have the financial motive. Oh, wait. Okay. So then she just blamed Melanie. Do you see what I did there? All Lori is trying to say is that she wouldn't have the financial motive. Melanie would. That is putting the blame on somebody else. That's a third party defense. Okay, let's keep going. So she can say what she wants to say and that she wasn't blaming her niece. But okay, I think she was blaming her niece. I think that's a third party defense right there. Anyway, and that's what they were warning her about. This is what this is. And she's like, yeah, I'm going forward with this. Her third main argument, though, in this motion for a retrial is abuse of discretion. She lists 3 separate reasons under this argument. The first one is the denial of Rule 13.5 hearing. Quote, on May 29th, 2025, after reviewing juror electronic questionnaire, defendant requested a probable cause hearing on aggravated circumstances pursuant to Arizona Rules of Criminal Procedure 13.5a. The court denied the request, stating the defendant was not entitled to a probable cause hearing, end quote. Second reason, not releasing the jury from the admonition on the record. Quote, so this is interesting to me. Wasn't expecting this one. She says, second reason, not releasing the jury from the admonition on the record. Quote, After the verdict was read on June 12th, 2025, the court dismissed the jury so that the parties could discuss whether an aggravation phase would be presented. I remember this. They dismissed the jury. Let's talk aggravation phase or not. Well, after the discussion relating to the denial of the Rule 13.5 hearing, the court set a sentencing date and dismissed the parties without bringing the jury back into the courtroom to officially lift the admonition and dismiss the jury, end quote. I did not see that one coming. So she's saying that they didn't officially lift the admonition and dismiss the jury. I'm looking forward to the court's response to that. I didn't know about that. Wasn't expecting that one. Never noticed. So I'll wait for the court's response to that one. Or by that I mean the state, the prosecution. Third reason. Allowing GSR and DNA evidence without sufficient foundation. DSR, by the way, is gunshot residue. So allowing GSR and DNA evidence without sufficient foundation and denial of right to confront witnesses. Quote, on May 3rd, 2025, the state filed a motion to preclude Brady material relating to the crime scene tech Tammy Lachik from Gilbert Police Department, who collected material evidence from the alleged crime scene. Brady material showing that the witness Lachik was implicated in an incident that resulted in her resignation was disclosed by the state on May 1st, 2025, even though the report was concluded on March 6th, 2025. Because of the late disclosure, defendant requested the court order the state to disclose the witness Lachik's employee file so that the defendant could thoroughly investigate any issues that might be relevant to this witness testifying at trial set to begin May 29th, 2025. The court denied this request. May 25th, 2025, the state notified defendant that 2 pages of this witness Lachik's notes, which other forensic scientists would have needed to rely upon or had relied upon, but were now missing and could not be provided to defense. On June 3rd, 2025, in the middle of trial, the state disclosed a letter from the witness Lachik indicating that she would not be testifying, and the defendant has offered Exhibit 203 marked for appellate purposes. Defendant objected prior to each forensic scientist, 2 from Mesa Crime Lab and 1 from the Phoenix Crime Lab, to the witnesses testifying about analysis they completed based on the work conducted by witness Lachik. The first witness was Emmeline Sapinoso, who created a profile from the blood blots collected by this witness at the autopsy of Alex Cox. The second analyst was Vanessa Mielke, who testified that the blood clot profile of Alex Cox matched DNA swabs taken by witness Lachik. From the Jeep Wrangler, finally, analyst Kyle Mueller, who testified about GSR gunshot residue particles found inside the Jeep that were collected by witness Lachik. Those objections were denied. End quote. So, Tammy Lachik, you can watch our entire episode on Tammy. There was a concern from Lori. She filed a motion explaining why she felt that Tammy Lachik was not an okay witness for the state to bring due to incidents that happened with Tammy when she was found in a hotel room where she was dismissed from Gilbert Police. Like, there was an incident, it had nothing to do with back in 2019, but years later. So I actually think it's wise in the end that the state did not call her. I was always wondering how this was going to go. And I even thought that was wise of the state to not call Tammy, because there could be an appeal. There is going to be something from Lori about this witness. Well, I guess that didn't keep Lori from having issues with this still. You don't have to call the witness for her to complain. So, she didn't even testify in the end. I'm going to share this episode in chat, and it'll also be in the description of this episode, so you can check it out. So after a few pages of bullet points and what I'll politely call Lori's greatest hits of grievances when it comes to the trial for Brandon Boudreaux, we finally get to the real meat of the motion, the part where she puts on her law school cap and starts citing statutes like she's clerking for the Arizona Supreme Court. Yes, welcome to the section I like to call Lawyer Lori. And this is where things get really interesting, really interesting. Suddenly, we're knee deep in legal citations, references to precedent, constitutional claims, and of course, accusations that her rights were trampled on because she was allegedly sick and she didn't get her way. Now, the question is any of it persuasive? Is any of it even accurate? We're about to find out because in just a moment, we're going to break down her legal arguments line by line, statute by statute, and unpack whether Lori's latest motion is this legitimate Hail Mary or just another episode of her courtroom theater, aka Groundhog's Day. Let's dive into the case law. But before we do that, a quick word from today's sponsor. As the weather heats up, it's time to rethink your skincare, especially if you're using retinol. Why? Because retinol can make your skin more sensitive to the sun. And that's why our house has made the switch to OneSkin's OS01 face moisturizer. And we are not looking back. In lab studies, OS01 boosted collagen just like retinol, but without the sun sensitivity. Even better, it strengthens your skin barrier instead of breaking it down, helping protect against heat, pollution, and everything else the world throws at your skin. Dr. John and I both use it. We love it. No irritation, no stickiness, just smooth, healthy skin that looks and feels youthful. OneSkin is the world's first skin longevity company, and by focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. For a limited time, you can try OneSkin with 15% off using code HIDDEN at oneskin.co. That's 15% off at OneSkin, ONESKIN.co with code HIDDEN. After you purchase, they will ask where you heard about them. Please support Hidden True Crime. Tell them we sent you. Give your skin the scientifically proven gentle care it deserves with OneSkin. All right, let's dive into the case law. She starts by writing, quote, "The Arizona rules of criminal procedure provide that a court may grant a new trial for any other reason not due to the defendant's own fault. The defendant has not received a fair and impartial trial," end quote. And then she quotes case law, Arizona, our criminal case law. It's always a little bit of legalese for me, forgive me. But as for her first point of Fourth Amendment violation, medical evaluation, Lori writes, quote, "A new trial is appropriate if, for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial." And then she cites Arizona Constitution. By forcing defendant to proceed with trial as her own counsel deprived her of the right to effective assistance of counsel. There is no honor in forcing this defendant to defend herself sick. There is no honor in ordering by any means necessary to ensure that you will be the judge to preside over this high-profile case. There is no honor in threatening defendant over and over that you will inform the jury that she was convicted of prior murders. Where is the honor in this court system? Okay, I just have to say that is such a strange choice of words, honor. Okay, moral police, sit down. This isn't, it's illegal or it's against the Constitution. There is no honor. I mean, this is like chastising a child. It's sort of like saying the evidence will show, the evidence will show, the evidence will show. There is no honor in threatening a defendant over and over that you will inform the jury that she was convicted of prior murders. Actually, it's the right thing to do when you continue to say that your character is fabulous and that you're such a good person and that the jury needs to know this. Actually, there is honor in telling you that if you continue down this route, they will be able to bring in your prior convictions. That would be the honorable thing to do, is to give you a chance to say, hold up, you might not want to keep talking about how great your character is, Lori, if you don't want us to bring up these past convictions. There is honor to actually warning the defendant of what might happen. And there's honor of the state in not moving forward to do that so quickly, but to slowly continue to warn her. There is no honor, Lori, in once an objection is made to things that could bring in your prior convictions, for for you to continue to repeat them over and over and over again. This just reeks. This is like the very reason that Lori gets under my skin. It just reeks of this moral superiority. There is no honor. I want to say, sit back down in your wheelchair and take a breath, because actually there is honor in this court system, whether you like it or not. But, like I told you, I'll give her some things. I'm not giving her this one. I will continue though. So for lack of impartiality, Lori writes, quote, "A defendant may move for a new trial based on the court's lack of impartiality." State versus Medina, 193, and then she cites some additional case law. While under the law, a trial court is presumed to be impartial and free from bias. This defendant can rebut this by the preponderance of the evidence by showing the court required her to present her defense strategy to the state before calling any witnesses. By denying defendant a thorough opportunity to present her case by preventing defendant from arguing objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents from him prior to cross-examining witnesses, this court established a lack of impartiality. During cross-examination, defendant was not allowed opportunities or even asked for responses to state's objections. Defendant was continuously admonished not to speak over the court. Yes, she was. Yet, when courts generally request a response from defense regarding objections, this defendant was not afforded that opportunity. When defendant attempted to explain why a statement was not hearsay, because it established how the police investigated the case, the court spoke over defendant, telling her the objection was sustained. When defendant requested a sidebar, it was denied. By not allowing defendant to question witnesses relating to Melanie Boudreau and how that could have impacted victim Brandon Boudreau, thoughts on why he blamed defendant, this court showed a lack of impartiality. Any attempt to present defendant's case was met with threats of informing the jury about defendant's prior convictions, end quote. Okay, I have to take a deep breath after that. Let's just pause here for a second, because this part is wild. Lori is acting like she was forced to reveal some top secret, foolproof defense strategy in open court, when in reality, she's never had to show a defense. And let's be honest, she's never really had one to begin with. In both of her Arizona cases, she rested before she even put on a single witness. And what the court did ask her to do, and what any defendant is asked to do, is simply prove that her witnesses were relevant. That's it. It's not groundbreaking. It's not unconstitutional. It's honestly, this is standard trial procedure. Because here's the thing. If I were on trial, I couldn't just call my neighbor's ex-boyfriend's mailman to take the stand to talk about, the other witness and say, I heard that they were, weren't a good person, and expect the court to roll with this. I'd actually have to show that they had some kind of knowledge about the case. And that's not oppression. That's just how trials work. And there's honor, Lori, to that system. But in Lori's world, being asked to show basic relevance is apparently a civil rights violation. So let's talk about another one of Lori's courtroom complaints. This idea that she was somehow denied her voice every time an objection was made. Now, I've sat through a good amount of trials now, and I can tell you defendants don't usually jump into objection battles. That's not how court works. When an attorney objects, the judge rules, sustained or overruled, maybe a quick explanation. Then it moves on. That's it. There's no dramatic back and forth, no open mic moment for the accused. This isn't Judge Judy. And that sidebar Lori's so upset about, it was denied after multiple sustained objections during a cross-examination. Judges are allowed to do that. In fact, a quick Google search or even just a glance at courtroom procedure will tell you that judges are not required to grant sidebars. Sure, they're common, especially for sensitive legal issues. But at the end of the day, it's completely at the judge's discretion. They can choose to hear the issue in open court or just tell the attorney to move it along. That's not unconstitutional. That's not unfair. That's just the courtroom doing its job. And I also want to point out that once an objection is made and sustained, Lori would defy that objection. And she would continue on saying the very thing that they objected to. Hey, Lori, for example, don't bring up Tylee as a witness. This is Charles's trial. What happens? That objection is sustained. You can't bring up Tylee. What would Lori do? Bring up Tylee right after. It was the objection is then objected, sustained. She brings up Tylee again. This is what Lori does. You know, sometimes I wish Judge Judy was in that courtroom. Judge Borowski, I thought, did a fine job. But, you know, where's Judge Judy when you need her? So once again, Lori is spinning this standard trial procedure into some grand injustice, and it's exhausting. I'm exhausted with her. But also, weirdly, it's on brand. Back to the legal battle, though. Okay, so argument 3, abuse of discretion. Lori writes, quote, the court abused its discretion by denying a probable cause hearing under Rule 13.5 on the aggravating factors alleged by the state. There's only one sentence allowed for the crime of conspiracy to commit first-degree murder, and therefore the state should not have been allowed to argue aggravating factors. The court abused its discretion by denying defendant a Rule 13.5 hearing. The court abused its discretion by failing to inform the jury on the record and in front of the parties that they were released from the admonition. Finally, by allowing the state to present evidence without a sufficient foundation, this court abused its discretion. Further, this defendant was denied her Sixth Amendment right to confront all witnesses. A clearly material witness was not allowed to be called, and then other analysts were allowed to testify to her work product in violation of Smith v. Arizona and the United States Confrontation Clause. I'll pause. That's interesting. So in other words, before trial began, Lori's issue was that the state was going to call Tammy Latchik and that she didn't feel, that she had character issues. So they didn't call her. And now Lori is saying that violates her rights because now she can't question this witness. In other words, this is a lose-lose for the state. Lori is going to file an appeal on this witness, whether the witness is called or isn't called. They can't win here. I'll continue. Further, defendant was precluded from investigating witness Latchik's employee file to see if there were other issues that would be allowed to impeach evidence during the trial. The court failed to conduct any evidentiary hearing and only issued a minute entry stating that the events happened after she collected the evidence. By preventing defendant from conducting an independent investigation into witness Latchik and conducting an evidentiary hearing, it abused its discretion, end quote. Okay. And now for Lori's grand finale, Lori's big finish, her courtroom firework moment. So you ready for this? She writes, and I quote, the state of Arizona does not honor the Constitution of the United States. The state of Arizona does not honor the constitutional rights of the accused or even the civil rights of the accused. For this purpose, a new trial is required, end quote. So just to recap, according to Lori, the entire state of Arizona, its courts, its judges, its law, its constitution is basically one big human rights violation. At this moment, forget the multiple guilty verdicts, forget the fact that she was granted an advisory council that basically acted as her attorneys in some ways, which she should have been her own attorney. That's what she requested. Forget the multiple hearings and the ability to file motion after motion from her cell. None of it matters because apparently Arizona is just too unconstitutional for Lauren Daybell. And they have no honor. I mean, that's one way to end the motion. Not with a strong legal argument, not with case law, but with this sort of scorched earth statement that would probably make James Madison roll in his grave. It's bold and it's so very Lori and so very on brand. The bottom line is Arizona is just unconstitutional. I think the other thing, that was it. That's her motion for a retrial. I think the other thing that just sort of makes me curious. Like I said, this motion for a retrial is on brand. Like I said, I was wondering for 2 weeks, like, why haven't we heard from her? Where's the motion demanding a retrial because she was sick? Like, I was waiting for it. I was checking the docket every day. Where is it? It came down today. And I thought, that's why I thought, I was like, maybe, just maybe she really is done. This would be like the greatest summer gift she could give us all. But like I said, I wanted to cover this because I'm so curious about what this is about. Like, does she want, or I mean, she's saying in this motion she wants a retrial, right? She wants a retrial for all these reasons. But why? Like, why? Like, this is for the attempted murder. Again, she's a serial killer. She has so many convictions. She doesn't want to stay in Arizona. She wants to get the hell out of Arizona. Excuse me. Like, she's done with Arizona. She wants to go back to Idaho where it's cozy, where she feels better about things. She doesn't want Judge Boreski to be her judge or Trina K or the state. So does she want a retrial? So she wants to face Judge Boreski again and Trina K again and the state of Arizona again and stay in Arizona. And for what? Because even if she were to have another retrial and she were to win, like, let's say this was even granted, like, best case scenario, I'll give it to you. There was no honor, Lori, so best case scenario, they're like, okay, we'll give you a retrial. She faces Judge Boreski again. She faces a new jury again. She faces Trina K again. She hangs out in Arizona longer. And for what? Like, she still has multiple life sentences. And so let's say the next jury is like, you know what? She's innocent. She didn't attempt to kill Brandon Boudreaux. It's Melanie's fault. Melanie Boudreaux-Pulowski, her not third party witness, the not third party witness. Sorry. Jody Hildebrandt joke, but like, come on, that was a third party witness. You just threw your niece under the bus. Don't tell me you did it. But what is the point? What does she want to accomplish? And so I haven't asked Dr. John this yet, but I suspect if we ask Colby, her only surviving child, or if we ask John, the answer would be attention. But Lori just wants attention. That would be so very on brand, which also, she says when she's there, she doesn't want the camera on her face. She doesn't want cameras in the courtroom. It's interesting to me. She doesn't want to stay in Arizona. But again and again and again, she wants a retrial. She wants to fight and argue. And maybe it isn't attention. Maybe it's control too. I mean, I guess those are the same thing. Does she want control? I don't know. I'm left with wondering, what is it that you want out of this? There are a few starred comments here. We're going to go over them. Thank you. Exactly, Bobby. It just seems like Lori isn't really ready to end the Lori show. I am, and I'm going to have to figure out where to end it on my end, just so you know. I'm debating that. But this one, I had to bring you guys. I'll know when I know. One of our presidents threw up all over a prime minister and he kept going. No excuses, Lori. Bianca, not easily. How are you able to be on TV with that cough? Clearly, I'm not. Forgive me. I'm working on it and I hope to have the solution soon. I also think it gets worse, by the way, I'm noticing when I bend over to read. So I might have to figure out a way to put my probable cause and motions up higher because I think bending over isn't helping. Bobby, thank you. Don't get in a wreck, Bobby. I'm glad you pulled over to type that one. We all saw water at her table, so we all know that one was BS. We saw water at the table, but none of us were in the holding cell, right? I assume she had water, but who knows? Lisa, exactly. She wants out of Arizona. Why another trial? The world according to Lori, right? Where nobody has any honor but herself. Aaron, Lori repeatedly began to open the door, so to speak, and blaming Melanice, among others, including victims, over and over. She's done these things. Exactly. Jake, you didn't say Uno. That means you draw 4 cards and I'm not guilty. That's extra funny to me because I've just been teaching my son how to play Uno, and we actually got in a fight yesterday over Uno. I said gotcha to my son, and he was very upset at me because, yeah, but exactly. But so like I can understand that example. This is like a game of Uno and draw 4 cards. Right. That's what she draw 4 cards. Not guilty. Granny, I'm so glad you've become granny to 13 grandkids. Thank you for becoming a member. McSpunky, always good to see McSpunky. Terrible twos here. Exactly. Lori entered the terrible twos and she never left it. And you know what? There's something to that, I want to say. Dr. John explains a lot actually when it comes to criminals or those that have these personality disorders and the way they think. It is sort of like a toddler having a tantrum. They want control. This is when a toddler starts to learn how they can control their caretaker, right? They drop something, the caretaker picks it up. They can't get what they want, they have a tantrum. Sort of the same thing. Kimberly, thank you so much. If she's been slightly as concerned about the rights of her victims and their friends and families' lives, these arguments might not seem so hypocritical and pathetic as they do. Infuriating. And you're exactly right. It takes everything in me to actually say, well, she has a point here and she has a point here, because we can't forget her victims' rights and what we have read and seen in the evidence. It's so difficult to put that aside. It's infuriating. You're absolutely right. Rosie, that's what I wonder. Does she want just another chance to appear on TV? What color is the sky in Lori's world? I would say yellow or pink. But you know what, Sharon? This question reminds me of something profound that Jodi Hildebrandt's niece stated to John DeLynn on Mormon Stories. Jesse Hildebrandt stated that others had stated about Jodi Hildebrandt that they feared Jodi Hildebrandt, that's Ruby Frankie's, sidekick, because if Jodi Hildebrandt said the sky was yellow, they would believe her. And there's something to a manipulative person being able to convince people of things that just seem completely impossible. What color is the sky? If Jodi Hildebrandt or Lori Vallow say it's yellow, you better believe him. Emily, honor. There is no honor in murdering 4 people and attempting to murder a 5th. Thank you. Right. Let's talk about honor, Lori. I think that's why I just find it so despicable, this self-righteous moral talk coming from her. Sit down, sit back in that wheelchair, Lori. Emily, always good to see you. She wants to continue punishing people. You're absolutely right. Absolutely right. She wants to continue punishing people and she wants control. Did she honorably, yes, do this to her kids, Tammy, Charles, and an attempted murder on Brandon? Yeah, again, talk about honor, Lori. Do we need to be worried, Tammy asks, that she's going to get another trial? I would not say that right now, no. I am not personally worried. I am interested in what the state's response is going to be, or Judge Boreski's response is going to be. And when that happens, we will go over it together. So, Ms. Angry Seth, thank you so much. Laura, welcome. Aaron, interesting how all sovereign citizens bring up how unconstitutional things are for them, but don't acknowledge the constitutional rights of everyone else. You're absolutely right. And if you're also referring to her father, Barry Cox, the apple doesn't fall far from the tree. Barry Cox also spent time behind bars because he didn't pay his taxes. And what did he do when he got out of prison? He wrote a book about how he was right and that no one should have to pay their taxes. And he cited God and scripture as his argument. So It is interesting how you're right. Sovereign citizens are always bringing up how unconstitutional things are without bringing up the fact that what they do and what everybody else's rights are have no bearing. Do you think she's trying to get another interview in prison? And this is her way of trying to make it happen? Interesting question. Possibly. She hasn't had another interview since her last guilty verdict. Where's Brianna when we need her? But actually, maybe they've declined her. Yeah, nobody's listening to her anymore. At this moment, does anybody care? She's making herself relevant again. We can only hope that she would represent Barry Morphew. Yeah, maybe she'll offer her services. Poor Lori. Her lawyer was incompetent and didn't understand the law. It's unfortunate, right? That her lawyer Lori didn't understand. Judy asking, did she ask for water and a blanket in the holding cell? I'm sure they would have given it to her. That's a good question too. I also always speculate. I know that she was offered medicine. Let's say that too, because she actually, let me point out this. I don't know the answer to that, Judy. But what I do know, because I saw it with my own eyes, was the judge offering medicine to her and somebody saying that she shouldn't be forced to take it. And another complaint she said was that she was given no medicine while in the holding cell. I feel certain they would have given it to her. I don't know about the water or the blanket. And I also want to point out that, of course, she's going to wait for transport. That makes sense. And I've always suspected this, if we get into Munchausen and how I suspect Lori, poisons people and controls people with substance, would she have drank the water? I have always wondered that if she was offered water, if she wouldn't drink it, just to show that she was dehydrated, to make her point. But who knows? Beth, thank you so much. Lori is waiting for her trial where she will be exonerated. I hate to tell her that she will not be exonerated in this life or the next. Heather, what I don't get is, if Jesus is going to get her out of jail one day, why is she trying to do this for herself? I guess she doesn't really believe that Jesus will do this, or if Jesus is her friend. I think it is control. Also, people bring up the translated being bit. If she's truly translated, why is she getting so sick? But yeah, I think that, again, I think this is about control to her. Mitzi, thank you for Hidden True Crime membership and gifting that. Georgiana, thank you so much as well. Thank you, everyone. Thank you. Mara is asking if people thought HTC's Munchausen episode. That's another one that I would recommend watching. Yes. Yeah, if somebody knows the Judge Boreski, you can send him a t-shirt. I am not going to ever contact the judge. I'm going to respectfully give my distance to Judge Boreski, but I think he's done a wonderful job. So, all right. Anything else? Thank you, everyone, for being here. Thank you. Like I said, I'm about ready to throw in the towel with Lori Vallow Daybell. I've said this before and I'll say it again. But I do feel this was important. It was a part of the trial that I just attended. And this is before the sentencing has even happened and when victims have had their opportunity to share how she has hurt and affected them. That sentencing will be coming up next month. And she's already fighting for a retrial before the victims have even had an opportunity to share what they want to share. So justice has been served. Let's hope soon, though, that we can all move on from Lori Vallow Daybell. We'll see everyone.